My name is João Pedro Quintais, and I'm assistant professor at the University of Amsterdam Institute for Information Law.
Hi, I'm Thomas Margoni. I'm a professor of intellectual property law at CITIP, University of Leuven, and a fellow at the Create Center.
My name is Ola Furcão. I'm a lecturer in intellectual property and information law at the University of Glasgow and member of the Create Center.
My name is Joost Poort. I work as an associate professor and co-director at the Institute for Information Law, University of Amsterdam.
Our particular research in this project relates to the application of EU copyright law to outputs generated by or with the assistance of an artificial intelligence or AI system, tool, or technique. So we call these AI outputs. Our focus is on outputs in the musical domain. So examples include musical compositions, lyrics, performances, sound recordings, and broadcasts or webcasts of such musical outputs that were generated with the assistance of AI tools. Now, the targets of our research in this project are quite broad. I would say, first and foremost, the focus is on policymakers and courts, which are struggling with how to legislate, make policy, and interpret existing law to the use of AI technology to produce creative content. But our research also aims at developers of AI systems and users like artists or performers, as it aims to clarify how the law would apply to their interaction with these types of AI systems.
So in our case, we are really looking at a specific technological technique that of text and data mining. So the extraction of information from literary and artistic works, such as articles or poems or books, images, sounds, you name it. Therefore, the kind of groups of people involved in this type of research are all people that will either benefit or being somehow impacted by this specific process and the way in which the legal system regulates it. So our specific analysis looked at two specific exceptions and limitations introduced recently at the EU level, and we have been analyzing the kind of impact on mainly technology companies and researcher, but also at the level of cultural and creative industries and users, that the specific shape that these exceptions have taken will influence the way in which it will influence their daily activities.
So our task focused on rights to revocation. So those are the rights that allow creators, authors, and performers to reclaim their rights after they were transferred to third parties, usually publishers or producers. So in our research, we were focusing on creators. So we were focusing on writers, songwriters, performers, composers, audiovisual authors, translators like literary translators, as well as creators' organizations representing them. So our focus in this research was quite narrow.
So the task I've been working on also focuses on a wide range of authors and creators. The work I've been doing is a survey amongst creators and performers, and to find out about their experiences in the digital age, with digital developments, with platforms, AI, and their earning developments also during COVID. So for the work I've been doing, the target group were all those performers and creators in the various disciplines.
Despite the rapid increase in the use of AI, there remains significant legal uncertainty about how to apply EU copyright law to AI outputs. So considering this uncertainty, what we try to do is set out to examine how could the law protect AI music outputs. With this in mind, our main objectives, I could group them into three buckets: to analyze the protection of AI outputs under EU copyright law, to examine the attribution of authorship and ownership to natural and legal persons involved in the production of AI outputs, and to formulate interpretative guidelines and policy recommendations on increasing legal certainty regarding the protection, authorship, and ownership of copyrights and related rights over these AI outputs, especially for our purposes, musical outputs. However, much of the same questions in research are also valid for the current wave of AI image generators like DALL-E, Stable Diffusion, Midjourney, and even more recently, text generators like the OpenAI's ChatGPT.
Our main goal, I think, has been to address the complexity connected with text and data mining from a legal and copyright point of view. And probably the single most challenging aspect here was to show how text and data mining is not just a copyright exception, so to speak, but in fact is a way of regulating technological development at the EU level. And this is probably an aspect that goes, we say, beyond what was the initial remit of this type of legislation. And therefore, it becomes particularly interesting to analyze the implications and the future developments in this area.
So when it comes to our task concerning rights of revocations, we had two goals, and both of those goals were connected to a knowledge gap. So first, rights of revocation is an institution which is not widely known. We know that a variety of member states have provisions allowing authors to reclaim their right, but we're not entirely sure how many of those provisions are there, what is their shape, how can they be triggered, who and how can actually exercise those rights. So first, we focused on mapping of reversion provisions in all EU member states, provisions which are currently a part of the national copyright laws, as well as those that historically were a part of laws of member states. And secondly, we focus on the knowledge gap associated with creators themselves. So we try to bring this knowledge that we gathered on provisions that are available to creators themselves. So we organized workshops, we produced a resource page, which hopefully creators will use to exercise and reclaim their rights back.
So the work I've been doing isn't so much about solving a particular problem. The work I've been doing is really about fact-finding. So we wanted to find out what concerns creators and performers in the digital age, their opinions and experiences, and to collect those in order also maybe to find avenues for future policy and to find out what's going on.
So in our project, we have a number of recommendations. I'll focus just on a few for legislators and policymakers. Counter a lot of calls that are out there for legal reform. We actually argue that there's no clear case for legislative action at the level of substantive rules in new copyright law in the short term as regards AI outputs. There's simply not enough evidence that the existing rules are not fit for purpose, at least from the perspective of major overhaul of these rules. As regards private parties, we actually found that EU copyright law is sufficiently flexible to provide to AI providers, developers, and users some interpretative space that they're actually using in practice and trying out different contractual arrangements for achieving whatever legal certainty and rights attribution they want. So far, we haven't seen too many disputes among private parties on the matter, and we feel this is where the action is, and research has actually not caught up with this, so we do make some recommendations to what needs further study. Actually, at this level, we think some future work in the policy arena would be better served rather than with new laws, with actual co-regulatory approaches or stakeholder dialogues that could identify and develop best practices and model clauses to guide AI service providers in order to be more fruitful and achieve like a better understanding of the technology before actually intervening with law. We have some concrete measures that we recommend from the legal perspective in the medium term, and those have mostly to do with the presumption of authorship and ownership in Article 5 of the Enforcement Directive. We actually argue that AI system users should retain the right to claim authorship over AI outputs that would qualify as copyright protected works as the result of their human contribution, as well as recourse to legally effective means to disclaim authorship of those outputs or parts thereof. Now, this matters because when we were designing proposals for the interpretation of existing rules, we proposed a 4-step test for assessing copyright protection of output created with AI or produced with AI that would qualify as a work. And we underpin our analysis around the notion of the human cause. And the linchpin of our analysis here, or the crux of it, is that copyright law should focus on and afford protection to human authors and human creation. And therefore, by focusing on that and on the existing legal framework, we could do away with some of the proposals and less, we think, well-guided normative interpretations of attributing rights to machines, for example, or creating sui generis regimes of protection.
In our task, we have summarized the two main type of recommendations. In the short term, certainly it would be important to monitor how member states are implementing at the national level these two exceptions. This process has almost ended, and it is interesting to note that despite the precision with which the two exceptions have been formulated at the EU level, there are still some margin of discretion that the member state have implemented, and therefore it will be interesting to see how what kind of real life impact these deviations have. At the same time, again, in the short term, it is likewise interesting and important for the involved parties to rely on the private ordering tools such as licenses that have been employed or applied to the original training material, because this can give a degree of certainty that goes beyond that afforded by the law in specific circumstances. A great example here that we have found is Wikipedia, that in the field of natural language processing is probably the most used databases in this case for literary sources. In the long term, and probably here, especially the EU level, is a very long term, certainly we would recommend to reconsider specifically the impact that a text and data mining exception, or perhaps a broader research right rule or norm will have on the European technological sector. We have found convincing evidence, as I mentioned before, that this exception is not, as I said, just a corporate exception, but has a direct impact in terms of the cost and the incentives that it creates to the technological development, especially in the field of data analytics, so AI and all these very important technologies at the EU level. And therefore, it will be important when the time is mature to reassess this specific situation.
So the main recommendation stemming from our task is that concerning the meaning of use in the digital environment. What we found is that variety or majority of reversion provisions that are currently existing in the European Union, as well as Article 22, so the revocation right triggered by lack of use, are connected to the use or the lack of use of works. However, we are not really certain what does it mean that a work is being used in the digital environment, and whether it is sufficient to conclude that a work is being used if it's simply made available or it can be made available on demand. So something that we would recommend is possibly a guidance or some sort of guiding intervention into understanding of use in the digital environment.
So in the work I've been doing, it wasn't about recommendations. It was more about fact-finding. We did find some interesting facts. Some of them were known in previous literature, for instance, that most artists and creators would like to work much more hours in their creative profession than they actually do, because they have to make a living combining jobs and doing other things. What we did find, which was new to literature, of course, was the huge COVID effect on their income. So they lost quite a significant share of their income, many of them, to because of the standstill in many professions as a consequence of COVID. Now, another thing that we did find, and we don't want to attach conclusions or recommendations to it, but that's what others might want to do, is that platforms nowadays are quite indispensable for creators and performers to promote their work, to find an audience. But in terms of income generation, it doesn't mean much for them yet. They don't get much income. Many of them suffer problems with platforms because their content is demoted or removed for no reasons given, or for the wrong reasons. For instance, art being mistaken for nudity or pornography. So they have a kind of a complex relation, as an understatement, with the platforms.
Well, one common misconception, mostly among developers and users, is that current copyright law is woefully inadequate and does not apply to AI-generated outputs at all. Our research does point to several elements of legal uncertainty, but that is, pun intended, certainly not the case. Another related misconception, this one among some scholars and policymakers, is that there is an urgent need and clear case to reform the law, in some instances to create a whole new regime for AI outputs. We see no clear normative or empirical case for this, even if some tweaks are needed. It doesn't mean that in the future there will not be, but as it currently stands now, there doesn't seem to be such a case. And finally, there are a number of misconceptions among developers and users, such as artists using AI tools, about how copyright law works, especially about who is the author and who owns the output. This was clear both from our interviews with experts and from reading the terms of service of multiple AI system providers, especially in the music field. So the answers are obviously not easy, so some confusion is understandable, and hopefully our research will help somewhat to clarify these aspects.
Probably the single most outstanding misconception is that the text and data mining exceptions are simply copyright exception, as I said. In fact, as we demonstrate, there is a much more important and wider impact on both the creative process and the technological development that the regulation of input data has. Under this point of view, the situation has improved considerably, especially for research and cultural institutions. Some uncertainty remains with regard to the categories that are not covered under Article 3. And this probably helps to a certain degree to have a situation that is not as clear as it could have been. But certainly the general direction has been towards clarity, and we hope that through the work we have been doing, we have clarified some of the enduring misconceptions.
I think the most common misconception when it comes to the revocation right is simply that they are not available to the European artists, because currently we see many cases being heavily reported on in American media about authors reclaiming their rights after a particular period of time has lapsed. So a lot of creators, sort of artists, believe that this is only a case and possibility to reclaim rights in the United States. So this most common misconception is simply that those rights are not available. And even if they are available, they are not really, they are not potentially beneficial to the creators because they apply only to the future contracts, which is also not the case, as the rights of revocation, even the one introduced just now by the copyright directive, does apply to the agreements which are already in force. So those agreements that are binding authors, and in the case that their works are not being exploited, authors can actually claim those rights. back already.
So all of our reports, publications, tutorials, blog posts, and related materials are available on the reCreating EU website. And additionally, we post most of the stuff on Zotero, and you'll find some of it on SSRN and on different affiliated blogs. But I would direct, for our topic at least, of AI outputs, to our report on AI music outputs, challenges to copyright protection at EU level.
I would just make one addition about the reversion rights resource page, where you can find all our mapping and all the reports and all the papers available in one place.